Is Collin Roth. I'm the communications director here at the Wisconsin Institute for Law and Liberty, also known as WIL. Thank you so much for joining us for this kind of special briefing and announcement about WIL's brand new initiative, the Equality Under the Law Project. This is kind of a culmination of a lot of stuff we've already been doing, but it's time to kind of roll this thing out and make it even bigger. I do want to say this presentation will be recorded and posted at a later time if you miss it or if you want to review it again. Also, please keep in mind that we're going to answer some questions and do some question and answer at the end of this conversation. So please put those down there in the chat or in the Q&A, and we will get to those towards the end. So I'm joined today by WIL President and General Counsel Rick Esenberg, as well as Deputy Counsel Dan Lennington. And I want to start with you, Rick. Let's set the table. What did you see in the last year that had you contemplating the need for a litigation center at WIL that would focus on equality under the law?
Well, I mean, like, I'm a bit older. I'm old enough to remember the tail end of the civil rights movement and have a sense of what life was like before then. One of my earliest memories of childhood is being at State Fair and seeing a young Black couple accosted by racial slurs by somebody who was refusing to serve them at a refreshment stand. And I remember the look of hurt on the faces of the Black gentleman and his wife or girlfriend, and remember internalizing as a very young child how awful this was. And so we had a problem. It took us way too long to realize what that problem was. The problem was that we were not treating people as individuals. We were treating them as members of groups. To use Dr. King's formulation, we were not judging people based upon the content of their character, but the color of their skin. And we came to see too long and with too much trouble how wrong that was. My concern now is that, to a degree that I would have thought unlikely, improbable, maybe even impossible, we're abandoning that insight. We're succumbing to easy answers in the notion that, to quote, one of the key critical race theorists, Ibram Kendi, there are too many of us who believe that the answer to racism in the past and discrimination in the past is to implement some form of discrimination in the present, that there's some type of recompense that can be achieved this way. I think that way lies disaster. I think that way will not address extending opportunities to people who may not have them in the way that we wish they did today. I think it will lead to division and will eventually lead to the re-racialization of our society and an abandonment of the principles that we fought so hard to get past. And so it occurred to me that what we needed to do at WIL, given the capabilities that we have, is to do what we can to resist this movement, to resist it through litigation, to resist it through public policy, and to resist it through public advocacy. And that's why we launched this project.
Dan, you joined WIL in January of this year, so you've been here about 6-7 months. Tell us a bit about yourself, how you arrived at WIL, and how you have approached this equality under the law work.
Thanks, Collin. Yeah, I've been practicing law for now 20 years. I got my start in a law firm in Michigan after I graduated from Hillsdale College and Valparaiso School of Law. After about 6 years in private practice, I moved into government service versus a federal prosecutor, and then at the Wisconsin Department of Justice, where I served as Assistant Deputy Attorney General for J.B. Van Hollen and Brad Schimmel. I too, like Rick, have some early memories of racism that really stuck into my mind. I grew up in a neighborhood where our good friends next door was a Black family who had 3 sons. Our family has 3 sons. We all went to high school together. We had neighborhood parties together. They were my babysitters growing up. And when I went into high school, I was on the basketball team, and I experienced racism against some of my Black friends as we went around Indiana playing basketball. And I just have always, ever since that experience of seeing my teammates the subject of racial slurs in the early 1990s, I've just always had this deep ingrained sense of injustice and wanting to right that wrong. And then in my experience in government, I've seen how easily bureaucrats can take away individual rights. So my view, becoming a lawyer, I've always viewed equality under the law as our most important constitutional right. When we think of our constitutional rights, we think of freedom of press, freedom of religion, the right to a fair trial, the Second Amendment. But in my view, those rights don't mean very much if the government can dole out rights and benefits based on your race or based on something other than your individuality. So I'm particularly interested in critical race theory also because I'm the father of 4 boys who are all in public school. And my wife and I have seen firsthand how critical race theory in schools, in public schools, is a toxic ideology, and it's taking over curriculum, and no one really is immune from this. It's even if you don't have children who are in schools, if you go to a workplace every day, or if you want to receive benefits from the government in some way, this is something that affects us all, and I'm very, very passionate about it.
Thanks, Dan. I want to go back to you, Rick. So you set the table for us on the need for this litigation center, the Equality Under the Law project. And we started the year looking for cases, plaintiffs, opportunities to weigh in. Take us through some of we've really filed 4 big cases this year in this sphere. Take us through those 4.
Well, so all of the cases that we've filed involve racial preferences. And there's been a debate in the law over the years as to how racial preferences are to be handled, particularly in the college admission context. The court has allowed race to be considered as a factor. You can't use a quota, it can't be dispositive, but you can take it into account. Sometimes it can be used in a remedial way if you have some discrete act of discrimination which has had an impact that cannot be readily addressed by identifying and making the victims whole. But the court has, the US Supreme Court has been pretty adamant in over 30 years now in making clear that racial classifications and preferences are disfavored. It's used terms like odious, highly suspect, antithetical to the values of the 14th Amendment, and they are subjected to strict scrutiny, which is a lawyerly term that means that they cannot be upheld unless they are narrowly tailored and necessary to achieve a compelling government interest. That's a very, very high burden to overcome. But yet, notwithstanding these legal obstacles, and what I think is relatively clear, if not quite complete, constitutional teaching, governments have been increasingly willing to abandon that and enact explicit racial preferences. So we have the 2 federal cases and the 2 state cases. In the COVID relief package that was passed early in the Biden administration, the administration asked for, and the Democrats in Congress provided a relief package, which really, in a way that I am hard pressed to find a precedent for, extended government benefits on the basis of race. One almost has to go back to Jim Crow to find something like this. But, the Vitolo case involved the Restaurant Revitalization Fund. Restaurant Revitalization Fund provided that there was a set amount of money that was going to be allocated to help restaurants who suffered during the pandemic. And the priority was going to be given essentially based upon race. When we worked through all the complexities, that's where we wind up. And it was pretty clear that the money would be exhausted before this priority ran out and all restaurant owners were considered to participate in the relief program. So we filed a lawsuit. We filed it down in Tennessee on behalf of Antonio Vitola, who runs a pizza joint in Harriman, Tennessee. And we were unsuccessful in the district court, but we were successful in the Sixth Circuit Court of Appeals. A divided panel gave us a very, very robust opinion affirming what the Supreme Court has always said, I think, and making clear that the Biden administration could not avoid these things by citing things like systemic and structural discrimination or simply pointing to racial disparities. So that was a very, very signal win, very, very early in this effort for us. The Faust case, our client Adam Faust is a disabled farmer in Chilton, involves another Biden COVID relief program, which again is extraordinary. It treats every minority farmer in the United States different than every non-minority farmer. It says that if you are a Black, Hispanic, Asian, or Native American farmer, your loans will be forgiven, all of your loans. Plus, you'll get a 20% add-on for your troubles. No white farmer will receive this benefit. Clearly unconstitutional. We brought an action up in the Eastern District of Wisconsin in the Green Bay Division on behalf of our client, Adam Faust, is our lead plaintiff, but we're also representing a number of farmers across the Upper Midwest. And the judge issued a temporary restraining order, and that was the order that halted the Biden administration program. So once again, a very, very substantial victory for us very early in our adoption of this effort before we even had a chance to publicly announce it. There are two state cases. One involves an older scholarship program in which scholarships are made available on the basis of race. You only get the scholarship if you're Black, Hispanic, Native American, and certain types, but not all types of Asians. One of our lead plaintiffs in that case is a woman who has immigrated to the United States from Thailand. She's not eligible. Her son's not eligible. The more recent state case involves the city of Madison. The city of Madison decided that it wants to have a police oversight board. That's fine. But what it did was it reserved most of the seats for members of racial minority groups. It's really an extraordinary thing, taking a governmental body and saying that only members of certain races may serve on this governmental body. That is something that I think runs afoul of these general principles that I outlined at the beginning. And we've challenged that as well. And believe me, and Dan can, I'm sure, concurs with this, there are going to be more cases because unfortunately, we find ourselves in a situation where these principles of race blindness and color neutrality and treating people as individuals and not as archetypes or members of a group, all of this stuff has come under attack. And it's come under attack in a way which is increasingly being expressed by the federal government, by Congress, by state legislatures, by local school boards across the country. And the only way for us to resist this and stop a descent into a divisive realm of identity politics in this country and a re-racialization of our public life is to resist it. And the way that we can resist it is through filing litigation and doing the other things that we do.
Thanks, Rick. And Rick kind of took us through some of the four big cases. I know, Dan, you have been involved in kind of keeping in touch with our clients, recruiting our clients, listening to our clients in these cases. I know something we say around here is, these cases involve real people. Tell me about your experience working with our clients in these cases. Who are some of these individuals that we're helping, and what really motivates them?
Right, thanks. This is it's really one of the joys of working at Will, is we get to represent these individuals. They all have really compelling stories. This is a thankless job to be a plaintiff. In many of these cases, there's not really a chance to see a financial outcome at the end of the day. We represent the clients pro bono. They don't have to pay any attorney's fees. And in these particular cases we filed, we don't actually have any promise of being awarded attorney's fees in most cases by the court. And so we do this pro bono, and we get to hear their stories. And these people, for example, our plaintiff in the scholarship case, her name is Kiki Rabidna. As Rick mentioned, she's an immigrant from Thailand. She's a nurse. She works very hard. She has multiple degrees. Her husband's a very hardworking bus driver for the city of Madison, and they have a teenage son. When we talked to her recently about why she's bringing this lawsuit, and you can see this interview on our website, will-law.org. You can see the interview with Kiki Rabidna and her husband. She repeats this phrase. She says, America is the land of opportunity, and it's for everyone. She says, America is a land of opportunity for everyone. And she's very passionate about her constitutional rights. And she's especially passionate about the idea that people should be treated equally. She has a teenage son who wants to go to college someday, but because he is not a Native American, a Hispanic, a Black American, or coming from Laos, Cambodia, or Vietnam, under Wisconsin state law, he is ineligible for a taxpayer-funded scholarship. And that's the reason we filed that lawsuit, Rabidna versus the Higher Educational Aids Board. Adam Faust is a very inspirational person in my view. He's a dairy farmer from Calumet County. He purchased his dairy farm from his parents. He lost both of his feet in a farming accident and also suffers from spina bifida. But according to the U.S. Department of Agriculture, he is not disadvantaged. And the U.S. Department of Agriculture says he's not disadvantaged because of the color of his skin. And when you talk to Adam about why he's joined the case, he tells me, he says, farming doesn't matter what your skin color is. The price of grain doesn't care. The weather doesn't care. The price of milk doesn't care what your race is. And the federal government shouldn't care what the color of your skin is either. So Adam, another person who's very passionate about the principle of equality under the law. And Tony Vitolo is the owner of Jake's Bar and Grill. He's married to a Hispanic woman, and he supports his wife and their children with the restaurant. But because Tony's wife only owns 50% of the restaurant and not 51% of the restaurant, the federal government, the Small Business Administration, said that Tony's restaurant's not eligible for COVID relief. Tony asked us to sue because he believes in the fundamental principle that government should treat everyone in a race-neutral fashion. The restaurant industry, interestingly, is actually the most diverse industry in America, and so it's frankly, ridiculous to restaurant owners that Congress and the Small Business Administration should try to give some benefit based on race in of all industries, the most diverse industry in America. Tony wrote a piece for the Federalist, which is online today. And one line that he wrote in there I thought was very interesting. He said that one day my business may not be here anymore, but the United States of America will be here. The most important thing to consider in this country is the country and the world that we're going to leave to our children. So a lot of our plaintiffs, they're focused on their children and what sort of what sort of country we're going to leave to them. Are we a country dedicated to the proposition that we're all created equally? Or are we dedicated to some principle of equity, which is going to be the redistribution of benefits?
And Rick, you already kind of mentioned this, but I want to just give you an opportunity to explain this further. We've done a lot of activity in a short period of time. Litigation often takes a long time, can take years in many cases, but two of our federal cases have already kind of achieved some results in court. Talk to me about, what has occurred in both Faust and Vitolo, and how big a deal are those?
Well, they're huge deals. Look, I mean, and I would say that, and I say this so often that I have to stop saying it, but I'm going to say it one more time. I've reached the point in life where a big part of my job is to take credit for what my younger colleagues do, and I'll it's not like I'm not involved, but I have to say that my younger colleagues exhaust me with the amount of credit taking that they force me to do. And I announced this initiative, and it never would have occurred to me that before we even were able to have a session like this, we would have taken down the Biden administration twice. Now, I also wouldn't have thought that the Biden administration would be as blatant and radical in what they attempted to do. And because they were so blatant and radical, because we had a situation where loans were going to be forgiven right away, and there would be no way to get that money back. Restaurant revitalization funds were going to go out the door, and there would be no way to get them back. We were able to take advantage of mechanisms in the law which allow you to get things that are called temporary restraining orders, preliminary injunctions, things that you can do to make, to halt that wrongdoing before it becomes impossible to do anything about it. And we were able, under very, very constrained, very, very short time frames, we were able to use those mechanisms to halt both of these programs. And so today, it's not perfect, but there are many restaurant owners who would not have seen a dime in COVID relief because of the color of their skin, who have been able to participate in that program because of the action that we brought, because of the injunction that we received in the Sixth Circuit Court of Appeals. This affects billions of dollars. Same thing with respect to the loan forgiveness program. Now, there's a lot of litigation that's left to go in that program, but think about it. Had those loans been forgiven, it would have been impossible for the federal government to get that money back. Because of course, farmers who benefited from it would have used the money. They would have invested in their farm, and there's nothing wrong with that. But it would have been something that is impossible to be undone. And again, it would have involved billions of dollars. And in both cases, we were able to put a hold on these programs so that the very, very serious constitutional questions that we and others have raised can be addressed.
Thanks, Rick. I want to go to you, Dan. So in addition to some of the lawsuits we've filed, Will is going to be engaging in the debate over critical race theory, and particularly where it's just kind of, this debate has exploded in academic curriculum in recent months. What is Will doing in this space? And if parents and taxpayers have concerns, what should they be looking for? And in what cases can Will offer assistance?
Right. So we've been talking to a lot of parents. I've been talking to parent groups from different school districts around the state. And I've also been talking to business owners who might not be eligible for certain benefits because of race, because of critical race theory. And to a lesser extent, we also talked to some employees who are seeing critical race theory at work in the form of diversity, equity, and inclusion training. So I would say primarily it's in schools right now, But no one is immune from this. It could be at your work, or if you just own a small business, the way you interact with the government is going to be affected by critical race theory. So when people ask me, what do I look for? I say, don't focus on what critical race theory is, focus on what it does. Focus on what it does, what is the ground truth, what is it, how is it actually impacting people in their everyday lives? So these are some of the examples I give people. If there's any evidence of segregation, that's something is a big red flag. If they're saying all the whites go here and the people of color, you go here, no matter if it's an exercise or whatever, that is a big red flag. Teachers, schools, employers, they do this, they call it affinity groups. Affinity groups is the top example. Any evidence of discrimination. For example, if your child's not eligible for a scholarship or some sort of award at school, or you're as an employee, you're not going to get some sort of award or benefit because of your race, that is something as illegal and discrimination. If there's any evidence of quotas, for example, a certain number of students or employees get this, or a certain number of people get this benefit based on your race, that's a red flag. Another category is compelled speech, forcing a student to say something like, I am a racist, or forcing a student to engage in something called a privilege walk. That may very well be a red flag to be concerned about. Now, when you get into compelled speech, we're primarily looking at what the government's forcing you to do. So public schools would be something to look at, or public employers. Also harassment based on race, shaming someone, criticizing someone, ascribing some sort of ill motives to someone based on the race or the color of skin, that's illegal. That should be something that should raise a red flag. Also, this concept of forced identity, forcing someone to identify. Tell me, what is your race? What is your gender? What is your sexual orientation? And then finally, the catch-all that I think people are much more familiar with is the idea of religious objections. So if you have a religious objection to something and your employer is making you do it, or your school district's making your child do it, that would be something to think about. So those are sort of the big categories of things that I look for when I look for evidence of future cases that we may want to bring.
Thanks, Dan. And anyone who just runs into this type of stuff or has questions about this stuff, you can head over to will-law.org. We have a request a lawyer or contact a lawyer tab. You can get in touch and we can evaluate whatever you might see or have. We can't promise anything up front, but we're always happy to try and help where we can and where it makes sense for this mission. We've got a couple questions here. I think I'll direct this one to Rick. What is the potential for progress in the legislative and executive branches with regard to critical race theory? The question says, we've been doing a lot of stuff in the courts. What are some of the policy options at the legislative or executive branch level?
Well, there are a lot of things that could be done on the legislative and executive branch level. The thing that has gotten a lot of attention right now are proposed laws that would restrict the teaching of critical race theory, or I think it's more accurate to say that would prohibit, because look, I mean, nobody makes 8-year-olds read Kimberly Crenshaw, believe me. I mean, I was talking to my wife about critical race theory, and she says, you know, I read what those people are saying, and I guess I'm not smart enough to understand it. And I said, oh, no, you're smart enough to know that it cannot be understood. It is so turgid, it is so dense, it is so self-referential and circular that nobody is making 12-year-olds even, or 14-year-olds read that stuff. But there are concepts that are derived from it, and those certainly are taught. And I think that Dan's description of what some of them were was very, very good. So there are efforts to restrict that. Now, in principle, this effort is perfectly appropriate because it wouldn't be in college. I think college has a trend or a tradition of academic freedom that needs to be respected. But in K-12 education, we really are dealing with government speech. K-12 teachers are not free to say what they want to or teach what they want to the way college professors are. They must implement the curriculum. It is what we call government speech, right? In public schools, the government is saying what the government chooses to say. Now, there are restrictions on that based on constitutional limitations, civil rights laws, things like that. So in principle, these efforts are perfectly appropriate. In practice, they're very, very difficult, because it's very, very difficult, particularly when you're trying to deal with local school officials who you don't trust, to describe what it is we do and do not want to see happen in a way which corresponds to, to prohibit only what we want to prohibit and not prohibit things that we don't want to prohibit. But I think that those efforts are perfectly appropriate, and we have been working on trying to fine-tune language that can be used in that type of legislation. I think that during the Trump administration, there were some attempts made by the Trump administration to restrict this activity in various parts of the federal government. I think that those efforts are all being reversed now by the Biden administration. We're not talking about going to court, we're talking about other things, but I think that there's opportunities for Congress to react to that in particular ways. Don't have the votes to do that now. The same thing is true on the state legislative level. So there are things that can be done. But the other thing that can be done, and I think I cannot emphasize this enough, is that we have to reinforce the culture of individual treatment, race neutrality, colorblindness. And I think the problem that we have right now is that too many people are afraid to stand up and say, look, you know what? Racism is horrible. And because it is horrible, we can't go down this path. People are afraid to say that because they're afraid of the accusations that will be leveled at them. They're afraid of being canceled. And although we can fight all of those things legally and legislatively and administratively, and we will do what we can, the most important thing is for citizens, ordinary people, to get up and say, no, this is not what this country is about. It took us too long to get off this path. We are not going to return to it, and we are not going to be afraid. We're going to speak the truth. We will not live by lies.
Thanks, Rick. We'll go to Dan with this question. And this kind of goes to something that a lot of people, just genuinely think about. So if race-based policies are unconstitutional, what are the options available for solving some of the issues that we see in our state? So Wisconsin has, worst in the nation Black maternal mortality rate, Black home ownership rate, Black incarceration rates. Here in education, we often talk about Black-white achievement gaps. How should we think about this when we're interested in equality under the law, and yet it appears that there are some kind of problems that seem to hurt one community over another?
Right. I'm offended by the notion that the color of your skin gives you an automatic disadvantage and makes you have a oppressed life. And so when I look at a lot of these arguments, I think it can't be the case that it's your color of your skin that's causing this. And if you look at the statistics, the causes of disadvantage are poverty. Poverty is race neutral. Whether you have a parent who's incarcerated, that's race neutral. Whether you are arrested for a felony, whether you do drugs, whether you come from a broken home, your neighborhood, your location, the state of Wisconsin can target the real causes of disadvantage in race neutral ways. Primarily, I would say, by targeting people who come from poor poverty-based backgrounds, and that helping people who need the help is much more affected and targeted than just saying, well, how much melanin do you have in your skin? That never can be the answer. It's not true. It's unconstitutional. It's illegal. It's immoral to say that. And I think if our goal is to help the disadvantaged, we should target what's causing the disadvantage, which is not what the color of your skin is. And we see this time and time again, especially with all the work that Will has done in the school choice area, to see how the achievement gaps in the very same neighborhoods have closed among the children who were allowed and permitted by the government to go to a choice school, and how those achievement gaps have closed with school choice. And so it's an instance of where we're helping the people in the way that they need help, the targeted relief, and not just broadly characterizing someone as saying, you are this color, therefore you need help.
Yeah, if I can just piggyback on that, I think it's important for us, just as it's important for us to say no, as I said before, it's also important for us to say, okay, we're going to commit ourselves to a full discussion and a full consideration of, what a race-neutral society ought to look like. And so, it's often said that when we have laws that address critical race theory, that this is just a way not to talk about America's racial past, not to talk about slavery, not to talk about Jim Crow, not to talk about anything. Well, I used to be a law professor. I used to talk about all of those things in almost all of my classes, not civil procedure. It's hard to work it in there, but although I think I sometimes did. And so, our partner organization, FAIR, is developing alternative curriculums and alternative trainings that strikes a balance that critical race-based theories don't strike. And I think Dan is absolutely right to suggest that when it comes to problems of poverty and lack of opportunity, we can debate about what the proper policy is, but what we ought to start with the assumption that treating people differently on the basis of their race is not something we should do. And then let's look for other ways to help folks, be it school choice or any other variety of problems, deregulation. There are solutions on the conservative side. There are solutions on the progressive side that have nothing to do with extending racial preferences.
Rick, I'll stay with you here. Any legal avenues available to the with regard to these issues with secular private schools, especially compelled speech regarding gender or racial identity?
Sometimes it depends. There can be if these schools receive governmental funding. There's also potential if these schools are subject, as most of them are, to federal and state non-discrimination laws, because, and here we get into a very, very rich and complicated legal debate, but there's something that is developed in the law of discrimination called hostile environment analysis. And so if I create, even if I don't exclude people of a certain race or certain gender from my classroom, if I create a hostile environment for them, if I make it impossible for them to participate in the educational program by the things I say, by the things I do, based upon their race or based upon their gender or some other protected classes, it gets complicated. That can lead to a cause of action. And so when it comes to secular private schools, if they go so far as to create a hostile environment, then there could be legal recourse. But it becomes a really, really difficult judgment, because hostile environment law itself can be abused. It can, it can impinge upon either legal protections or cultural protections or institutional protections for freedom of speech. So it really is something which is should be limited to the most extreme cases. But believe me, we've got examples of extreme cases.
And Dan, last question here. Do you think that the Biden administration, now that it's been kind of knocked around in court a little bit, do you think they'll change direction and start following the constitutional precedent?
Well, yeah, I see that questions from Adam Faust, our plaintiff in the loan forgiveness program. Thanks, Adam, for the question. And thanks for joining us. I don't think so. I think they're going to keep doing it. I just talked to a U.S. Senator's office today, and I posed this very question to them because they were talking to me about some of the legislation that's coming down the pike with the so-called infrastructure bill or the new reconciliation bill. And I said, is the word disadvantage still in those proposals? And they said, yes, it's all over. Now, the word disadvantage is a proxy for race. It's a code word. Congress is too embarrassed even to write racism right into their own law. So they use this euphemism called disadvantage, social disadvantage, or economically disadvantaged. And they said, yes, they're Nancy Pelosi and the senator, the Democratic senators are still writing in these racial preferences all throughout the infrastructure bill, all throughout the reconciliation bill. They're going to keep doing it until they lose power. And they know this is unconstitutional and this is illegal. But I fear that their theory is that they just want to run the ball as far down the field as they can until they get tackled. And we're going to have to send out lawyers and file lawsuits and tackle them on the field as much as we can.
Thanks, Dan. I want to wrap this up real quick. Rick, how can supporters help with the Equality Under the Law project?
Well, look, I mean, let me dispense with the obvious one. We are a nonprofit organization. We employ people who are really the best of the best. The lawyers that we have are the equivalent of lawyers that you're going to find in the best law firms in the country. In fact, many of us used to work for the best law firms in the country, and that's not cheap. And so the provision of financial support and partnership is very, very important. As I said before, understanding that this is something that we should not be afraid to speak out about and advocate for and not be intimidated is very, very important. Helping to spread the word about lawsuits that have been filed, proposals that have been made, legislation that is under review, administrative rules that have been promulgated. And you can get all of this information by, going to our website. I guess we have a new URL now for this project. It's www.defendequality.org. Is that right? Yeah,
that's right.
I don't want to get it wrong. And you'll be able to learn what's going on. There are other good organizations. I mentioned FAIR earlier. That's a great source for information about this issue. But it's important because we always cite the exchange between Ben Franklin and who knows whether it really happened, and a woman as he left the Constitutional Convention, and she said, "What do we have, doctor? Do we have a monarchy or a republic?" And he said, "A republic if you can keep it." We always quote Ronald Reagan, who says that liberty is never more than one generation away from extinction. And I think the thing that we need to keep in mind is that what we're seeing here, if you read folks who advocate for these ideas whether it's under the guise of critical race theory or elsewhere, they say, look, this is what we're doing. We are challenging the values of the Enlightenment. We are challenging the assumptions of liberalism, not Democratic Party liberalism, but classical liberalism, the tradition in which the American founding rests. We're challenging constitutional theory. We're challenging equality theory. This is a very, very liberal and I think ultimately very, very corrosive and dangerous concept. And so, we're a nonprofit. We need to keep the lights on. Please help us if you can. but this is also a fight that I think we all need to engage in, because this is serious stuff, and we ought not to be intimidated. We ought to speak up for our country. We need to recognize its flaws, but in recognizing its flaws, we cannot lose sight of the fact of its extraordinary strengths, in the way that it was this extraordinary strengths, this commitment to liberty and equality under the law, and treating people as individuals, that led to the and continue to lead to the exploitation of these flaws.
On that, Rick Esenberg, Dan Lennington, thank you so much to everyone who joined us this morning. I think this was a great opportunity to kind of explain what we're doing, what we have been doing, and what we hope to be doing going forward. We think this new project comes just at a really important time, not just for our state, not just for our community, but for our entire nation. We welcome your help in spreading the word about WILL, the Wisconsin Institute for Law and Liberty, and the Equality Under the Law project. Head on over to defendequality.org. You can sign up for updates. You can learn about our cases. You can read the various opinion pieces, see the interviews from Fox News that Rick and Adam Faust have been doing lately, and keep in touch with our work. So thank you so much, everyone, for joining us this morning, and keep up the fight.